So we'll discuss the 19th problem, 18th problem, and that is A was killed on the spot in a collision between a motorcycle and a motor car. His administrator claimed damages for the loss of expectation of life for the benefit to the estate. Will he succeed? The facts of the problem are similar to those in the case of Morgan versus Clouding, and it was a case of 1938 decided by the King's Bench. The facts of the case were the deceased was killed instantaneously in a collision between a motorcycle and a motor car. The administrator claimed damages for loss of expectation of life for the benefit of the estate. It was contended that no damages for loss of expectation of life could be recovered when the death instances. It was held that the cause of action was not death but the collision, that although there might have been only a split second or a very short interval of time between the collision and death of the deceased, the cause of action arose before the death, and that damages were recoverable for the loss of expectation of life. Therefore, in our problem also, the administrator will succeed. And now we'll go to the 19th problem. The defendant detained plaintiff's cow when it had trespassed on defendant's land and caused loss to his crops. The cow, however, died while defendant's possession for no fault of his. The plaintiff sued the defendant for wrongful conversion. Will he succeed? So, the present problem of the case as regarding to the facts of the problem, it resembles to those of the case of Mithau versus Naked if 1904. In this case, the defendant seized the plaintiff's cow on the ground that it has trespassed the previous day into their cotton plantation and refused to give it up. The cow, while into their custody, suddenly died. The plaintiff sued for the value of the cow. It was held that the death of the cow was not a natural or probable result of the seizure and detention, and the defendant was therefore not liable. Therefore, in our problem, also the plaintiff will not succeed. And now we'll discuss the 20th problem, and that is some traders with a view to drive another trader doing the same business out of trade combined and offered special terms to customers. The trader sued the other trader for loss caused to him. Will he succeed? The facts of this problem are similar to those in the case of Mogul Steamship Company versus MacGregor Grove and Company in the year 1922. In this case, A, B, C, and D ship owners who shipped tea from one port to another combined together to drive E, a rival ship owner, out of the trade by offering special terms to customers who would deal with them to the exclusion of E. He sued A, B, C, and D for the loss caused to him by their act, and it was held that he had no right of action, for no legal right of he had been infringed. Damage done by competition in trade was not actionable. Therefore, on the authority of the case, the trader in our problem will also fail. And now we'll go to the 21 problem, and that is in a fight between two buffaloes belonging to different owners, one was killed. Can, can the owner whose buffalo was killed sue the owner of the other for compensation? So, in this case, we found the very problem is similar to the leading case, Mangal Singh versus Lan Singh in 1870, in a fight between two buffaloes belonging to different owners. One was killed. It was held that the owner of the buffalo which killed the other was not liable to make compensation in the absence of neglect or carelessness on his part in keeping the animal. Therefore, in our problem, also the owner whose buffalo was killed cannot sue the owner of the other until some neglected or carelessness is there on of the owner whose buffalo killed the other. And now we'll go to problem number 22, and that is the defendant's cat strayed from his land to that of the plaintiff and killed some fowls and pigeons there. Consider the liability of the defendant, and this problem is similar to the case of Buckle versus Holmes in 1926, decided by the King's Bench. And the fact of the case, a cat strayed from its owner's land of a neighbor and killed fowls and pigeons kept there. It was held that the owner of the cat was not liable. Therefore, in our problem also, the defendant is not liable. And in our next upcoming video, we'll discuss the other remaining problems.